You're walking out of your home, keys in one hand, your day planned like any other. But there's one decision that quietly follows you everywhere, whether you choose to carry a firearm for personal protection. Now imagine waking up to headlines claiming the Supreme Court has just changed the rules nationwide. Not in theory, but in a way that could affect what is legal for you today, right now, in your own state. That kind of shift doesn't just stay in courtrooms. It reaches into everyday life, into routine choices, into moments you never expected to question. So here's the question. If the Supreme Court truly changed concealed carry laws across the country, do you think that strengthens constitutional rights or creates new legal uncertainty for everyday people? Share your answer in the comments. There has been increasing discussion online around what is being described as a 6-3 Supreme Court ruling in a case often referred to as Ramirez vs. California, with claims that it changes concealed carry laws nationwide. But before drawing conclusions, it's essential to carefully examine what is verified, what is legally accurate, and how Supreme Court decisions actually function in practice. In my legal analysis, one of the most important starting points is understanding that not every widely shared case name or claim reflects an officially recognized Supreme Court decision in the way it is being described. The court's rulings are documented in formal opinions, and any nationwide legal change would be clearly reflected in those records. That said, the broader issue being discussed, concealed carry rights under the Second Amendment, is very real and has been the subject of significant Supreme Court attention in recent years. To understand the current legal framework, we need to step back and look at how concealed carry laws have evolved historically. For much of American history, states had wide discretion to regulate how firearms could be carried in public. Some states adopted what are known as may-issue systems, where authorities could deny concealed carry permits unless an applicant demonstrated a specific need. Others adopted shall-issue systems, where permits were granted as long as objective criteria were met. This variation created a patchwork of laws across the country. What was legal in one state could be restricted in another. That landscape began to shift significantly with Supreme Court precedent. In District of Columbia versus Heller, the court affirmed that the Second Amendment protects an individual right to possess firearms for lawful purposes, such as self-defense, within the home. Later, in McDonald versus City of Chicago, that right was incorporated against the states through the 14th Amendment, meaning state and local governments were also bound by it. More recently, in New York State Rifle and Pistol Association versus Bruin, the court addressed the issue of public carry more directly. The ruling held that requiring individuals to demonstrate proper cause to carry a firearm in public was inconsistent with the Second Amendment. That decision marked a major shift. It established that the right to carry firearms for self-defense extends beyond the home, and it introduced a new standard for evaluating gun laws, one based on historical tradition rather than balancing tests. Now, this is where many current claims about new rulings begin to connect with reality, but also where misunderstandings can happen. In my legal analysis, what we are likely seeing is not a single new ruling suddenly changing everything nationwide, but rather the continued impact and interpretation of existing Supreme Court precedent being discussed, debated, and sometimes misrepresented. Courts across the country are still applying the framework established in Bruin. They are examining whether modern concealed carry restrictions align with historical firearm regulations. And this process is ongoing. There is a strong constitutional argument that laws restricting concealed carry must now be justified through historical analogs. That means governments must show that similar restrictions existed at the time of the founding or are consistent with that tradition. Courts would likely examine whether specific regulations, such as location-based restrictions, licensing requirements, or training mandates, fit within that historical framework. But it's important to understand that this does not automatically eliminate all regulations. States still retain authority to impose certain conditions on carrying firearms, particularly in what are considered sensitive places, or through objective licensing systems. The legal debate is about where the line is drawn, not whether any line can exist. This brings us to the federal versus state dynamic. Gun laws in the United States operate within a dual system. The federal government sets certain baseline rules, but states have significant power to regulate firearms within their jurisdictions, as long as those regulations do not violate constitutional protections. So even when the Supreme Court issues a decision, the way the decision is implemented can vary. States may revise their laws, courts may interpret those revisions differently, and new legal challenges may arise. From a real-world perspective, this means that lawful gun owners cannot rely solely on headlines or generalized claims. The specific laws in their state and how those laws are being interpreted matter enormously. Now let's talk about practical impact, because this is where the legal theory meets everyday life. For someone who lawfully carries a firearm, the question is not just, is this legal, but under what conditions is this legal? Where can you carry? What documentation is required? Are there places where carry is restricted? How do local enforcement practices align with state law? These are not abstract questions. They are the kinds of details that can determine whether someone is fully compliant or unknowingly at risk. And that brings us to legal risk. Even in a system that recognizes constitutional rights, failing to comply with specific legal requirements can lead to serious consequences. This could include permit violations, entering restricted areas while carrying, or misunderstanding reciprocity laws between states. In my legal analysis, one of the most overlooked risks is not intentional violation, but confusion. Laws are evolving, court decisions are being interpreted in real time, and public information is not always clear or consistent. That creates a situation where individuals must be proactive in understanding the law, rather than reactive after a problem occurs. At the same time, supporters of expanded concealed carry rights argue that recent legal developments are a necessary correction. They believe that constitutional rights should not depend on discretionary approval, and that law-abiding citizens should have clear, accessible pathways to exercise those rights. On the other side, those who support stricter regulations often emphasize public safety concerns. They argue that states should retain flexibility to impose conditions that reflect modern realities, even if those conditions were not explicitly present in historical regulations. Both perspectives are part of the legal conversation, and both influence how courts approach these issues. Looking ahead, the political reality is that nationwide uniformity in concealed carry laws is unlikely to come from a single ruling alone. Instead, change will continue to occur through a combination of court decisions, legislative adjustments, and ongoing legal challenges. In my legal analysis, the courts will continue refining the boundaries of the Second Amendment, particularly as new cases test how far the Bruin framework extends. And this process takes time. It is not instantaneous. It is not always clear, but it is deeply consequential. Because at the end of the day, this is not just about legal theory. It's about how constitutional rights are understood, applied, and lived in everyday situations. And that brings us to an important point to reflect on. If the law is evolving and interpretations are still being shaped, then the responsibility to stay informed becomes part of exercising the right itself. So before we go further, think about this. When you hear claims about major legal changes, do you rely on headlines, or do you take the time to understand what the law actually says and how it applies to you? Hold on to that thought, because in the next part, we're going to go deeper into how courts analyze these cases, what future rulings could look like, and what it all means for lawful gun owners moving forward. If you're finding this breakdown helpful, make sure to stay with me, because the details matter, and the next part connects everything in a way that could directly affect how these laws are applied in the near future. Now, building on everything we've discussed, the next question is how courts are actually applying these principles in real cases, and what that means going forward. In my legal analysis, one of the most important shifts we're seeing is not just in outcomes, but in how judges approach the reasoning itself. After recent Supreme Court precedent, courts are no longer relying as heavily on balancing tests that weigh public safety against individual rights. Instead, they are focusing on whether a law is consistent with the historical understanding of the Second Amendment. That may sound straightforward, but in practice, it introduces a new layer of complexity. Courts would likely examine historical laws from the 18th and 19th centuries to determine whether similar restrictions existed. If a modern law lacks a clear historical analog, it may face constitutional challenges. But if governments can demonstrate a tradition of regulating certain types of conduct, courts may uphold those laws. This creates a legal environment where outcomes are highly dependent on how history is interpreted. There is a strong constitutional argument that the right to carry a firearm for self-defense extends beyond the home and should not be limited by overly discretionary licensing systems. At the same time, another perspective raised in court is that certain regulations, such as training requirements or location-based restrictions, are consistent with historical practices and therefore remain valid. What this means in practical terms is that concealed carry laws are not disappearing. They are being redefined. Some states have moved toward more permissive systems, including permitless carry in certain cases. Others have revised their laws to comply with Supreme Court guidance while still maintaining structured licensing frameworks. And in many places, those new laws are already being challenged in court. This ongoing cycle, law, challenge, interpretation, is how constitutional law evolves. Now let's bring this back to real-world impact, because that's where this conversation truly matters. For lawful gun owners, the biggest takeaway is that rights and responsibilities are closely tied. The recognition of a constitutional right does not remove the need to understand how that right is regulated in your specific jurisdiction. For example, even if carrying a firearm is broadly permitted, there may still be restrictions on where it can be carried. Certain public locations may be designated as sensitive areas. There may be requirements related to how the firearm is stored, transported, or disclosed in certain situations. Courts would likely examine whether these restrictions are consistent with historical tradition, but until those questions are fully resolved, they remain enforceable in many jurisdictions. This is where legal risk becomes very real. Non-compliance, whether intentional or accidental, can lead to serious consequences. And in many cases, those consequences arise not because someone intended to break the law, but because they misunderstood it. In my legal analysis, one of the most important habits for any lawful gun owner is staying updated. Laws change. Court rulings shift interpretations. What was acceptable a few years ago may be subject to new rules today. And that's not just a legal responsibility, it's a practical one. Because when you're in a real-world situation, whether it's carrying in public, interacting with law enforcement, or traveling across state lines, the law applies in real time, not in theory. Now let's talk about the broader implications. Supporters of expanded Second Amendment protections often argue that recent legal developments are restoring the original meaning of the Constitution. They believe that individuals should not need to justify their right to carry a firearm, and that the law should provide clear and consistent protection for lawful behavior. On the other hand, those who support more regulation emphasize that modern society presents challenges that did not exist in earlier historical periods. They argue that states should have the flexibility to address those challenges while still respecting constitutional boundaries. Both of these perspectives are reflected in ongoing legal debates, and both influence how courts approach future cases. Looking at the political reality, it's unlikely that a single Supreme Court decision, real or perceived, will instantly standardize concealed carry laws across all 50 states. The United States legal system is designed to allow variation, especially in areas traditionally regulated by states. However, Supreme Court precedent does set boundaries. It defines what states cannot do, even if it does not dictate every detail of what they must do. In my legal analysis, the long-term direction is toward greater clarification rather than sudden transformation. Courts will continue to refine how the Second Amendment applies outside the home, how it interacts with public safety concerns, and how historical analysis should be conducted. And that process will shape future laws in ways that are gradual but significant. There is also an important constitutional interaction to keep in mind beyond the Second Amendment. The Fourth Amendment continues to play a critical role, particularly in situations involving law enforcement encounters. If an individual is lawfully carrying a firearm, courts may examine how that fact influences police authority during stops, searches, or detentions. The Fifth Amendment can also come into play in certain contexts, particularly regarding how individuals communicate during legal encounters. While exercising rights must always be done lawfully and respectfully, understanding those rights is part of navigating the legal system effectively. All of these elements, Second, Fourth, and Fifth Amendment considerations, combine to form a complex but structured legal framework. And that brings us to the most important point of this entire discussion. The law is not just something written in court opinions. It's something that affects real decisions, real interactions, and real outcomes. It's the difference between certainty and confusion, between compliance and unintended risk, between knowing your rights and assuming them. So when you see headlines about major rulings, sweeping changes, or nationwide impacts, the most valuable thing you can do is pause, verify, and understand what is actually being said and what it really means. Because in a system as complex as constitutional law, clarity is not always immediate, but it is always essential. Now, as we come to the end of this discussion, I want to leave you with one final thought to reflect on. Do you believe the current legal framework provides enough clarity for responsible gun owners to confidently follow the law? Or do you think there is still too much uncertainty in how these rights are defined and applied? Share your perspective in the comments and keep the discussion respectful and thoughtful. If you value clear, fact-based explanations of legal issues that directly impact everyday life, make sure to subscribe and stay updated. Because understanding the law is not about reacting to headlines, it's about being informed before the moment arrives.